Thank you. Sorry. Very much appreciate the chance to be here today. Appreciate the welcome. And believe me, we are incredibly lucky today. But to remind us about where we are and what's happening, I am Mike Gerhardt. I'm the scholar in residence at the National Constitution Center, also a constitutional law professor at the University of North Carolina. I have the great privilege of being the moderator for today's terrific program. I don't have the usual introduction with regard to asking you to please turn off your cell phones and silence them, and otherwise do what you can to kind of reduce the sound. Also, but I do want to remind you that there will be people coming around taking questions, written questions that you may have for our speakers today. We're moving a little faster than usual because it's just an incredibly special day. We have two fabulous scholars that are here to talk about a subject we actually don't get to talk about very much, which is corporations and the extent of their constitutional protections. And maybe ask the big question, how in the world did that happen? And we have, as I said, and as I hope you know, two terrific people. I will introduce them briefly, and then we're going to get to our discussion. We have to my immediate left, Kent Greenfield, who's professor of law and Michael and Helen Lee Distinguished Scholar at Boston College Law School. Kent has a number of distinctions, including the fact that he has a forthcoming book called Corporations Are People Too, and They Should Act Like It. Besides being very well published, Kent clerk for Justice David Souter in the United States Supreme Court, and he has practiced law at Covington and Burling. He also recently co-authored an amicus brief in the Masterpiece Cake Shop case pending before the Supreme Court. And to my far left, Adam Winkler. Adam is the professor of law at UCLA Law School and the author of, as you know, the book, We the Corporations, How American Businesses Won Their Civil Rights and Gunfight. And the also author of Gunfight, The Battle Over the Right to Bear Arms in America. Adam has a knack for picking exactly the most timely subject you could possibly imagine. His scholarship has been cited in the United States Supreme Court, among other places. And he is a frequent commentator, as you may recognize, from all sorts of programs all over the country. And he's co-editor of the Encyclopedia of the American Constitution, second edition, among many other things. So we've got an incredibly important subject today, and I want to just hit the ground running if I can. I'm going to turn to Adam first to sort of help us with the larger question, which is really raised by the titles of your two books about corporations. And Kent's title is obviously about corporations, but he says corporations might be people to some extent. Adam, where do you come down on that question after having thought about it for a long time?
Right, well, it's a great question. There's been so much controversy over corporate personhood since the Citizens United decision in 2010. That was a case where the Supreme Court held that corporations have the same right as individuals to spend their money on election ads. And this has put sort of a public spotlight on this question. Are corporations people, and what does that mean? But the idea of corporate personhood is actually a very long one, a very well-established legal principle. And in fact, if you go back to 1757 and you read Blackstone's influential Commentaries on the Laws of England, one of the most influential law books ever written, he describes corporations as artificial persons 300 years ago. Corporate law has really, since that time, always treated corporations as being people. Now, that's not to say they're exactly the same as you and me. If you prick them, they do not bleed. The idea of personhood is that a corporation is its own independent entity in the eyes of the law. Totally wholly and apart, separate and apart from the stockholders or the people who form or organize the corporation. That's a real key principle in corporate law today, for instance. So if you slip and fall at a Starbucks, you can't sue the individual shareholders of Starbucks. You have to sue the corporation, right? That's because the shareholders have limited liability. They're separate legal persons than the corporation. So the idea that the corporation is a person is just the idea it has its own independent identity in the eyes of the law. What's become so controversial in recent years is that the courts use that idea of corporate personhood to then say that corporations have many of the same rights that the Constitution guarantees to persons and to citizens. And that's a much more controversial way of thinking about corporate personhood. And in many ways, as I'm sure our conversation will reveal, I'm of the opinion that actually the reason why corporations have so many rights today is not because of corporate personhood, but actually in fundamental ways because the Supreme Court ignores corporate personhood. That the Supreme Court generally gives corporations and allows corporations to exert the exact same rights as its members. So the fact that the members have the rights means that the corporation has the rights. And that's a violation of the idea of corporate personhood, the idea that they're separate legal persons with separate legal rights.
So Kent, your title, among other things, suggests that they're people. But of course, you also write in your book, which will be forthcoming later this year, but you also write about how their corporations are a little different than people too. So would you agree with most of what Adam said, or where would you disagree?
Yes, absolutely I would. And one of the things to remember is that corporate personhood is one of the engines for economic development, as it turns out, because what enables corporations to make money is to separate the investors from the entity, so that the entity itself has its own liabilities, has its own legal powers, and doesn't depend on attaching shareholders. One of the differences between a partnership, for example, and a corporation is that a partnership is liable for all the acts of all the partners. If a partner commits a tort, then the partnership has to pay for it. That's not true about corporations. And one of the big legal innovations of our economic development worldwide, in fact, was this development of corporate personhood. Now, of course, the difficulty is when does corporate personhood, as a matter of corporate governance, get transformed into legal rights, especially in the constitutional world? And there, too, I think that it's because that they are economic entities, there are some totally easy cases. For example, because of the property entities that have the purpose of making money, there are a bunch of constitutional rights that are about property rights. The takings clause that prohibits the government from taking property without due compensation. Of course, that should flow to corporate entities. If the company could go into Coca-Cola and take out and say, okay, we own that secret recipe, or go into the New York Times and seize the printing press of the New York Times without compensation, nobody would invest in the corporations, and corporations would cease to be able to fulfill their institutional purpose. I think and then of course there are some rights that certainly should not flow to corporate entities, or in fact any associational entity. The right to vote. It just doesn't make any sense to think of a collective body, whether it be Planned Parenthood, the Boy Scouts, the NRA, or GE, to be able to vote. So some rights clearly ought to flow to corporate entities, and some rights clearly should not. But where the fights are, where the interesting conversations are, what happens to these middle grounds? What happens to these rights that pertain to and spring from interests in liberty and equality and speech?
Well, what our discussion is going to help us do today is almost begin to look at constitutional law from an entirely different perspective, kind of tell that same story, but it's a story about the rise of corporations' constitutional entitlements. It has a beginning, of course, and Adam traces this history in his book, takes us back to the early 19th century into some of the greatest lawyers in American history, including Daniel Webster. Adam, tell us a little bit about how this story begins, how corporations begin to win entitlements really to some degree of constitutional protection.
Sure. And we see, cases like Citizens United. It seems like a new controversy, the idea of corporations having constitutional rights. It's not something we had ever really thought of much. And in fact, if you open up any constitutional law textbook used in law schools today, there's no section in there on the constitutional rights of corporations. It just was never really studied before. People really didn't think about it very much, except for haphazardly or here and there. But it turns out that corporations have been fighting since America's earliest days to win equal rights under the Constitution. And corporations don't, march on the street with signs demanding equal rights like women and minorities did to win their equal rights. But corporations have fought a 200-year battle in the Supreme Court of the United States to get landmark rulings extending fundamental rights to corporate entities. And to put this in some perspective, the first Supreme Court case on the rights of African Americans was decided in 1857, the Dred Scott case. The first Supreme Court case on the rights of women was decided in 1873, the Bradwell versus Illinois case. The first Supreme Court case on the rights of business corporations was decided in 1809, a half century earlier. That case was brought by a corporation that was very popular here in Philadelphia at the time, the Bank of the United States, the first Bank of the United States. The building is right around the corner, and it brought the first Supreme Court case. The Bank of the United States sought the right to sue in federal court under a provision of the Constitution known as Article 3. And this provides a right of citizens of one state to sue in federal court if you're suing citizens of another state. And the Bank of the United States wanted to file a lawsuit against Georgia, people in Georgia, and it went to federal court and said, we want to be able to file suit in federal court, even though the text of the Constitution refers only to citizens having that right. But the Bank of the United States, aided by some excellent lawyers, was able to convince the Supreme Court in that 1809 case to say that corporations were protected by this provision of the Constitution. They did have the right to sue in federal court, even though that right was only guaranteed to citizens. And again, corporations won that first case, and they've been winning cases ever since.
Well, in fact, maybe it's helpful, Kent, to talk about one of those other big cases that was decided early on. And this is a little bit of a surprise if we think about it. I don't know much about corporate law, by the way. We're all getting educated about that today. But usually I think we think of corporations being formed because of state law. There's state legal provisions and procedures that have to go on through in order for a corporation to be established or chartered. However, one of the earliest cases, a case called McCulloch versus Maryland, involves actually a federal corporation, federal business known as the Bank of the United States, as Adam just referred to. What happens in that case?
Well, it was the case where John Marshall decides that, yes, Congress can create this bank, and it's one of the efforts on John Marshall's side to be much more expansive about the rights of the federal government. He says, we must remember that it is a constitution we are expounding. So we are a government of enumerated powers, but there's not really a power that says we can create the Bank of the United States, but we're just going to assume it exists from the necessary and proper clause and other things. So the one takeaway perhaps from that is that even in our earliest days of the nation, as a tool to expand federal power, the way that came about was aiming at corporate entities and looking at business, not at the rights of mortals.
So Adam, now we're going to pick up again with this, really the litigation that's shaping, for lack of a better phrase, corporate power. And one of the things that you and I talked about not too long ago, just in the green room, was a little bit about the rise of corporate power isn't linear. It doesn't necessarily go in a straight line. There's some pushback. And some of that pushback on the Supreme Court comes from a surprising direction. Chief Justice Roger Taney is remembered for his horrific decision in Dred Scott versus Sanford. But he also has other decisions too, which to some extent are pushing back against this rise of corporate power. Tell us a little bit about that.
Right, well, Roger Taney, Chief Justice of the Supreme Court, author of the notorious Dred Scott case that you mentioned, certainly one of the most reviled figures in the history of the Supreme Court, really. If there's one surprising thing I found in writing We the Corporations is that there's one feature of Roger Taney that many people today might appreciate nonetheless, which was that he was a corporate reformer who was opposed to expansive rights for corporations. And even in the Taney Court in the 1830s, 40s, and 50s, the Supreme Court faced the question of whether corporations should have constitutional rights. And the Taney Court really limited those rights, tried to scale back the rights of business corporations. And so Tawney was a surprising supporter of the idea of limiting the rights of corporations. Interestingly, you mentioned Daniel Webster earlier, and right outside there's a great Daniel Webster quote in the entryway of the National Constitution Center about one country and one constitution. Webster, in his lifetime, was known as the defender of the Constitution. Maybe one of the greatest Supreme Court advocates ever in American history, argued over 220 cases in the Supreme Court, at a time in the early 1800s when many of the provisions of the Constitution were first being interpreted by the Supreme Court. So he was incredibly influential. But he could have been known as the defender of the corporation, that his clients were by and large business corporations, and many of his most important victories in the Supreme Court were expanding the rights of businesses and merchants and the elites who he represented. And one of the stories I tell about lawyers and Daniel Webster and how he fits in, one of the reasons why corporations have been so successful in winning constitutional rights is that corporations have always had the best, most highest paid creative lawyers the nation can afford. No, to go file risky lawsuits, spend the money, try it, be innovative. Civil rights movement for women or for racial minorities, they've had some great lawyers, Thurgood Marshall, Ruth Bader Ginsburg. You don't get better than that. But they were always underfunded, and they didn't have the financing to hire more lawyers and better lawyers and additional lawyers and fight these novel, risky cases. Corporations always did have those resources, and so the ability to hire people like Daniel Webster to take your cases before justices like Roger Taney was a big advantage for corporations.
Well, as a law professor, I'm always obliged to drop a footnote. So let me drop a quick footnote that is about Daniel Webster, because in one of these earlier cases that Adam's referring to, a case that we sometimes don't associate with corporations, but it's really a case which is driven to some extent by business. It's a case called Gibbons versus Ogden, and a case that's very, very important to the scope of congressional power, particularly congressional power to regulate interstate commerce, perhaps Congress's most potent authority. But that case, which gives rise to a broad construction of Congress's power to regulate interstate commerce, is driven in a fight over steamships and steamboats and the business of running those steamboats. So as we relearn in constitutional law here, we might want to recognize that so much of that history is intertwined with business and the rise of business. Adam?
Well, that's right. And so the reason businesses seek constitutional rights for the same reason anyone else does, right? In the sense that they want to be free from government regulation, right? If you're an LGBT person, you don't want the government coming in and telling you who you can have sex with or not. And corporations similarly don't want to have government coming in and telling them how they can do their business or what they can invest in. So they use those constitutional rights to fight off against government regulation. The difference here is that they're not being regulated to reflect some sort of ancient morality about equality or whatnot. They're being regulated in the interest of the public and in investors and in the environment, and yet corporations are able to use those rights to fight back. And indeed, because of those resources, corporations have really been on the cutting edge of American constitutional law. And one of the most surprising things I found in writing the book was not just that corporations have been fighting for equal rights for 200 years, and there's a civil rights movement that we've kind of never heard of, but that in fighting for civil rights, they've been constitutional innovators. Like they've really been on the cutting edge of American constitutional law, breathing life, helping to breathe life into some of our most important constitutional rights. So it's a complicated story. It's not a screed against corporations. Right. It's much more nuanced, I think.
So one of the things that's interesting about this era, I think, is the court itself, including John Marshall, didn't have a clear conception of what a corporation was. And I think in some ways it was conflicting. And I think we still live with the problem of what is the right metaphor for a corporation? Is it a team? Is it an association? Is it its own person? And one of the earliest cases was the Dartmouth College case, right, where the state of New Hampshire was wanting to change the makeup of the personality of Dartmouth College from a private school to a public school, and Dartmouth College sued. And in that court, and the Dartmouth College was alleging that it had a constitutional right not to have its contract with the state changed. But John Marshall said in that opinion, the corporation possesses only those properties which the charter confers upon it. So in some ways he was saying, well, the state gets to decide what powers you have. But at the end of that sentence, I didn't read it all, it says, It gets all the powers that the state gives it or is incidental to its very existence. So you get what the state gives it and whatever you had that's just by nature that you get. So in some ways, the debate that we still have is what powers are created that are very just incidental to the very creation of a corporation. And you know why that's important? You don't know what's incidental to the corporation, and John Marshall didn't know 200 years ago. You don't know what's incidental until you know what a corporation is and have a pretty robust theory of what it's for.
Dartmouth College case, of course, argued by Daniel Webster, who loved Dartmouth College. He was an alum of Dartmouth College, and of course expressed that great line at some point in the argument saying, it's a small college, but there are those who love it, which turned out to be a winning argument in the Supreme Court. But Kent, our story, of course, as you both have pointed out, gets more complicated. Along the way, we get the 14th Amendment. At the end of the first sort of phase, we'll think of it as sort of antebellum period, end of the Civil War, we get the 14th Amendment, which, among other things, protects persons, guarantees to persons the equal protection of the laws, guarantees to persons that they won't have their life, liberty, or property deprived without due process of law. But the 14th Amendment term person is going to be interpreted early on to include not women, but to include corporations. So what happens in that early history?
I really think this is a question for Adam, because Adam has some great stuff in his book about this very case. I've got stuff in my book too about the case, but let him talk about the history.
Okay.
Well, so this 14th Amendment is it's actually one of the most bizarre and disturbing stories in American constitutional law, actually. And the 14th Amendment was adopted after the Civil War to guarantee the rights of the newly freed slaves. But about 15 years after it was ratified, in the 1880s, the Southern Pacific Railroad Company launched a remarkable series of what its lawyers called test cases, more than 60 of them in all, seeking rights under the 14th Amendment for business corporations too. And they hired a lawyer by the name of Roscoe Conkling, who at the time, the name not very familiar, but at the time was a very illustrious politician. He was one of the leaders in the Republican Party in Congress for about 15 years. He had been nominated to serve on the Supreme Court himself twice. The second time he was confirmed and turned the seat down, becoming the last person ever to turn down a seat on the Supreme Court after having been confirmed. And he was pretty honest about his reasons. He was making too much money as a lawyer for the railroads. And Conkling went to the Supreme Court and he said that the 14th Amendment was written not just to protect slaves, but also to protect business corporations. And Conkling had unusual credibility. Not only was he a man who had been nominated to the Supreme Court himself, a peer to the justices, but he was the last surviving member of the drafting committee of the 14th Amendment. He had been one of the men who wrote the 14th Amendment. And he even pulled out he said that the amendment had been changed, the drafting had been changed at some point, specifically from guaranteeing equal protection of the law for citizens to guaranteeing equal protection of the law for persons. And he said specifically to include business corporations. And he even produced a musty old journal that he claimed was a never-before published record of the deliberations of the drafting committee. Like I said, there was no one left, other surviving members to contrast his story or contradict him. It turns out that historians later looked into his story, and it turns out that Roscoe Conkling had simply lied to the Supreme Court of the United States. The Supreme Court actually never ruled on his case, holding on to it for about 3 years. And then another one of the Southern Pacific Railroad's test cases made it up to the Supreme Court a couple years later, presenting the exact same issue, but Conkling was no longer involved. And the Supreme Court, in that second case, ruled on it, but said, hey, we're not going to rule on this big constitutional question. This raises another issue we can address, but we're not going to say anything about whether corporations have rights under the 14th Amendment. And at the time, the court reporter, the clerical person who writes and publishes the Supreme Court's opinions, traditionally puts a summary of the opinion right at the beginning. And in the beginning of the second Southern Pacific Railroad case, the reporter included a summary that said that the court had decided that corporations were persons under the 14th Amendment to the Constitution, something the court had clearly not said in the opinion. A few years later, a justice, a somewhat nefarious-minded justice by the name of Stephen Field, one of the most colorful men ever to sit on the Supreme Court, the only Supreme Court justice ever arrested for a crime while he was on the Supreme Court, the crime was murder. So he was innocent, of course, but he was guilty, we might say, of desperately wanting to expand the rights of corporations. And in a case a couple years later, he said, look at that. Remember, in the Southern Pacific Railroad case a few years ago, we decided that corporations were protected by the 14th Amendment. And ever since then, that Southern Pacific Railroad case that does not hold that corporations have rights under the 14th Amendment has been cited over and over again by the Supreme Court, by lower courts, for saying that corporations have rights under the 14th Amendment. One final factoid, in 1912, there was a study done of 14th Amendment cases, and in the 44 years of the 14th Amendment, the Supreme Court had heard 28 cases on the 14th Amendment rights of African Americans in that time. In that same period of time, the Supreme Court heard 312 cases on the rights of business corporations. So it's a real story of how corporations took over the 14th Amendment.
Now here's another, let me tell you the corporate law story that is really important in this era. So meanwhile, right, while the Supreme Court is saying, corporations, you have rights. You have rights of citizenship, rights that are shared by persons in the constitutional law space. What was happening in the business law space? The big case had to do with Henry Ford. Henry Ford had a bunch of failed businesses, but in the early 1900s or early 20th century, he created his masterpiece, the Model T. Right? It could come in any color you wanted, as long as it was black. They were making money hand over fist. He had started the company with $100,000 of equity in the early 20th century. About 10, 12 years later, he was making and distributing in dividends to all the shareholders. He was the primary shareholder, but to all the shareholders, their initial investment every month. His investors, by the time the case comes around, had made a 40,000% return on their initial money. They had gotten rich. And so he actually became, he started saying, well, the purpose of corporations is actually to benefit all people. He added, now we now know that Henry Ford was a bad person in a lot of ways. He was anti-Semitic, he was an apologist for the Nazis, but at this time of his career, he was actually an advocate for the working class. He raised his wages without needing to $5 a day. And people were beating down his door to work for Ford. And he decided one day that he was not going to issue any more dividends because he wanted to build a big plant to employ even more people, he said. And he wanted to keep wages high because he said it's better for thousands of workers to be well-paid, well-fed, and well-satisfied at work than to make rich people even richer. That's pretty radical.
Right.
So he got sued. Right? He got sued. He got sued by whom? By the shareholders. You know who his primary shareholders were other than him? The Dodge brothers. You may know their name because they were creating their competitor company at the same time. So why did they want Ford to give them money? So they could finance their own company. And of course, Ford had all kinds of business reasons to say no. I mean, these days, courts, and even then, courts defer to the business judgment of executive. But what Ford said to the court in a deposition, no, I'm not doing this for business reasons. I'm doing this for social reasons. And this was an era where people were in the United States were really, this was the Russian Revolution, Eugene Debs was increasing, and the courts could not stand the thought that corporations could be about something other than shareholder wealth. And the court in Michigan, as it turns out, issued an opinion. That is still one of the first opinions that you read in a corporate law case. You read Marbury, you read McCulloch in con law. In corporate law, you read Dodge v. Ford. And it says the purpose of the corporation is to serve the shareholders. So I think that is corporate law's original sin. So at the same time that you had this enlargement of the rights of corporations to have the rights of citizens, you have a narrowing of their social obligation. And in fact, a prohibition on the corporation being more robust and attentive to their social obligations. And in some ways, it's the nightmare scenario. a robust set of constitutional rights that are exercised for the benefit of a sliver of financial and managerial elites.
Well, the sinfulness will actually spread to some extent because
as it does.
And Adam, as you know, in this period, and we're talking about the early 1900s, among other things, there's another movement going on. Of course, it's being driven by corporations. This other movement goes by different names: economic due process, the right to contract, sometimes called the Lochner Era, partly because, of course, Lochner was a very important case in this era. So tell us about this period of time insofar as constitutional law, and particularly the 14th Amendment's relevance to our discussion.
Right, so the Lochner Era is a period that's famous in the Supreme Court's history, roughly from 1890s to 1937. And it's a period where the court is very business friendly, and it becomes famous, notorious even, for striking down laws for regulating businesses on a whole variety of grounds. And indeed, at this time, corporations are really spurred to bring cases whenever laws regulate them because they think there's a chance of success. And even if they lose, they can raise the cost to lawmakers of regulating them because they have to spend money defending those laws in court. And so corporations really flooded the Supreme Court with constitutional law cases at the time. Well, we think of Citizens United and a big case coming up, but in the 19-teens, a whole bunch of cases came up and legal issues. Corporations brought constitutional challenges to nearly everything and raised equal protection claims, due process claims, claims under the Fourth Amendment against unreasonable searches and seizures, Fifth Amendment claims against rights of self-incrimination, freedom of association claims. And interestingly, the court in the Lochner Era, although it was a very business-friendly period in the court's history, the court at that time actually drew some of the first boundaries on the rights of corporations. The Supreme Court in the Lochner Era said corporations are entitled to property rights. As Kent said earlier, right, they need property rights. Government shouldn't be able to come in and take their property without paying just compensation. But that they shouldn't have, the court said, corporations shouldn't have liberty rights. The rights that are associated with personal conscience, political freedom, and bodily integrity, those are the rights that are designed for natural persons, not artificial persons. And 100 years before Citizens United, the courts had cases where corporations, mostly liquor companies in the run-up to Prohibition, filed challenges to campaign finance laws that restricted corporate money in elections. They went to court and said these are unconstitutional. But back then, the court said, no, those laws, these campaign finance laws, are perfectly constitutional. They're perfectly permissible because the right to influence politics belongs to natural persons, not artificial persons. It's a line between property rights and liberty rights that today's Supreme Court really has lost sight of. Today we're expanding the rights of corporations to participate in politics, whereas even under the Lochner Era, when the court was so business friendly, the court was limiting the ability of corporations to make such claims.
Which brings us, of course, to the next era, the New Deal, but also we've got the Civil Rights Era. Kent, what's happening in corporate law in this period? And of course, constitutional law may be important as well.
So a couple things, right? That there's a change in mindset in constitutional law to think instead of the rights of the constitutional rights are just negative rights, but there's a more sense of that the government ought to be involved in the economy, ought to be regulating the economy. So a move from the strict scrutiny of economic regulations in the Lochner Era to a more rational basis review. So that allows the Congress to pass a bunch of laws during the New Deal. And if you think about it, the important laws of the New Deal are much about regulating corporations. Mm-hmm. You know, the Great Securities Acts, the National Labor Relations Act, consumer credit protection. That's expanded, if you think of this as a broader period, into the 60s and the 70s even with the Civil Rights Act. If you think of the Civil Rights Act, it's limitations on business, on their ability to discriminate against people who in hiring and firing and in service. The Clean Water Act, the Clean Air Act. Meanwhile, in corporate law and in corporate governance, there was a big change sort of as a matter of theory within the New Deal. And the theory there was a real pushback against this notion that corporations are just about money. I think there were a number of academics, you know, a lot of academics The work of academics are ignored, and a lot of them should be. Sure, not us, of course. People should listen to us. But there was a sense. One of the most important theoretical changes in this era was a book written by Burley and Means, two law professors, who said that, you know what, the companies have changed what kind of entities they are. Instead of being entities where the shareholders are really closely linked to management, what was happening then was that management and shareholders became separated. There was a separation between management and control. Ownership, the shareholders, and control. And what Burley and Means said was, actually that gives us a space to impose more social obligations, more public obligations on these big entities. They affect people. They rule people's lives. And shareholders, instead of thinking of themselves as owners, we should think of them more as investors. And the collective nature of corporations became brought more to the fore. And I think there was a period of time in that middle of the 20th century where managers of corporations thought of themselves as more professionals. They were a profession that had social obligations that extended beyond what you would see on the bottom line.
Well, Adam, in the law, of course, another concept is going to become really important. And we've kind of touched on it before, but now we need to sort of focus on it more directly, and that's the personhood concept, the idea that corporations may turn out to be treated as persons for purposes of constitutional law. At what point does that concept kick in?
Right. Well, I mean, in some ways, it goes all the way back to that first 1809 case with the
Right.
Bank of the United States, when the corporation said we're citizens under Article 3 of the Constitution. So in some ways, the idea is really a very long and established one in terms of corporations seeking personhood. But one of the interesting things I find in my book is that if we think of corporate personhood as this idea that a corporation is an independent entity in the eyes of the law with its own rights wholly separate from the rights of shareholders. We take that as our understanding of corporate personhood. When the court approaches corporations like that, the court has historically limited and reduced the rights of corporations. It hasn't given them the same rights as people. It's generally said corporations are unique kinds of people and they're separate from the people within them. An example from the early 20th century, for most of human history, corporations were not subject to criminal penalty. They were thought not to be capable of devising the mental state that's necessary to commit a crime. But that changes about 100, 120 years ago. And when corporations first start being brought up on charges for criminal complaints, they go to court and say, we think we should be protected by the Constitution's provisions that protect criminal defendants. You know, if you look at the Bill of Rights, it's mostly about the investigation, prosecution, and punishment of criminals. And corporations went to court and said, like criminal defendants, we have a right against unreasonable searches and seizures. We have a right against self-incrimination, like criminals. And there was a case involving Teddy Roosevelt, who's also got a quote out there in the front hallway. And Roosevelt's famous for his antitrust prosecutions, right, cracking down on the big trusts. And he subpoenas the executives of the tobacco company to come testify before the grand jury because he's going after the tobacco trust. And the tobacco companies say, wait a second, having our own officers testify against us, that's a violation of our Fifth Amendment right against self-incrimination. And the Supreme Court rejects that argument and says, no, corporations don't have that right against self-incrimination. If the officer testifies, the officer is a separate legal person from the corporation, so it's not self-incrimination. And so when the court has divided, it's seen a separation between the rights of the members and the rights of the corporate entity, it's generally resulted in corporations having more limited rights. So it's one of the odd things about corporate personhood is that it's often used to limit the rights of corporations, right, not always to expand the rights of corporations.
I want to foreshadow something, because I know we're running chronologically, but I think this is a really important point, and it's a really important point now. Okay. For example, you've heard of the Hobby Lobby case that the court decided several years ago. You hear about the Masterpiece Cake Shop case that the court is hearing this term. Hobby Lobby was about a company that said, look, we've got our shareholders are religious. We should not be forced by Obamacare at the time to distribute contraceptives to our employees or provide health insurance that would allow them to buy contraceptives. That's against the company's religious beliefs. The court, and in fact, I helped write a brief and file a brief in that case, arguing for corporate personhood. Like, why would I do that? Because, like Adam said, if the court had taken seriously the notion of corporate personhood, that means separation. The reason the corporation was asserting religious conscious rights was not because the company was a religious company, it sold arts and crafts. But it was because the shareholders were religious. And so the court allowed the shareholders to project their religious conscience rights onto the corporation. That's a rejection of corporate personhood, not its embrace. The same is true about Masterpiece Cake Shop. This is the case where the baker is an evangelical Christian, refused to provide a wedding cake to a same-sex couple that came into his shop. And he says, look, I've got a religious right not to endorse your wedding, not to use my speech. And this is like forcing me to say the Pledge of Allegiance if I don't want to say the Pledge of Allegiance. But why is the case called Masterpiece Cake Shop? Because the company is the plaintiff, or actually the defendant in that case, not the individual. So I wrote a brief in that case too. Someday the court might listen to me, but I argued to the court, and it was signed by a bunch of corporate law professors. Corporate law professors are playing now. We have to start being involved in the constitutional law space. And what was our argument? Our argument was corporate personhood. Apply corporate personhood in this case, because if you apply corporate personhood, that means there's a separation between the company, the bakery, and the shareholder. He formed a corporation, not as an individual proprietorship, not as a partnership, to separate himself from the liabilities, the costs of the company. And as we said in the brief, you cannot have your cake and eat it too.
We're going to
It
find
was
out.
one of my best lines of all time. I'm going to be saying it all the time.
But now we're going to have to find out if that actually translates into a constitutional principle or not.
Right.
I was going to say, and this is an issue we have confronted before, the Masterpiece Cake Shop issue. And the question is, this baker in Colorado who doesn't want to provide this wedding cake to a same-sex couple, we've seen this before. If we go back in the 1960s, for instance, when the Civil Rights Act was banned public accommodations from discriminating on the basis of race, corporations went to the Supreme Court and went to the lower federal courts arguing that this law violated their constitutional rights. Their arguments weren't necessarily the exact same in terms of expression, customizable cakes, because it wasn't customizable, but you tried to use the Constitution and say we shouldn't have to serve customers we don't want to serve. And if we want to discriminate on the basis of race, that's our constitutional right. And the courts rejected that argument in the Civil Rights era. And indeed, I found even going back in the Lochner era, there was a case back in 1907 where the Supreme Court said specifically that corporations do not have a constitutional right to refuse to do service with customers that it doesn't want to do business with. And it dealt with a civil rights statute, a public access statute in California, and a racetrack that didn't want to let certain people come onto its grounds. And the Supreme Court said back then, that's not the kind of right that a corporation has, a right to keep people out. If you're open to the public, you're open to the public. That's a line that the Supreme Court seems to be on the verge of forgetting. This Masterpiece Cake Shop case could be one where not only the court ignores corporate personhood, but carves an exception out for businesses so that they don't have to follow basic civil rights principles, which would be, I think, highly problematic.
Well, I do want to get back to we're going to get to another major current case. And I'm going to come to you on that in a second, Kent. Of course, this case is well known, called Citizens United. But before I get there, Adam, I want you just to round out your history a little more, if you don't mind, to tell us about the participation on the court of one particular justice who comes to the court with a particular, I don't know that one might call it agenda, but interest in protecting corporations. And it may be surprising to a lot of people. And this is Lewis Powell, one of President Nixon's appointees, who comes there having served, among other things, the Chamber of Commerce. And so what is Powell's impact here?
Yeah, well, Lewis Powell is a really interesting thing. One of the fun things about writing the book was to get involved in the stories of great characters like the Daniel Websters and the Stephen Fields and the Roscoe Conklings, and indeed here too. Lewis Powell was one of these characters, and if Daniel Webster was sort of the defender of the corporation, in many ways Lewis Powell was sort of the corporation's most favorite justice on the Supreme Court, because Lewis Powell was, before he joins the Supreme Court in 1971, he writes a memo for the Chamber of Commerce. This is the era of Nader and the era of Clean Air Acts and environmental regulation and consumer protection laws being passed. And Powell is opposed to this. And Powell thinks that the left and Nader have gotten way too much power. So he writes a memo to the Chamber of Commerce, advising how the Chamber of Commerce should organize businesses to mobilize and to fight back against Nader and the left. And this memo, he writes to the Chamber of Commerce, and then 3 months later, he's appointed to the Supreme Court. And no one knows about the memo at the time, but the memo goes on to become a very, very influential planning document for businesses to mobilize, and businesses which had often been on the sidelines of partisan politics before the 1970s, they decide they're going to get really active and really mobilize, and indeed in the last 30, 40 years have really exerted their political power perhaps more than ever. And Powell gets the chance when he's on the Supreme Court to actually operationalize his own memo. And in an important case in the 1970s, 30 years before Citizens United, he writes an opinion for the court holding that corporations have rights of political speech under the First Amendment, and gives them that constitutional right to fight back. One of the most remarkable things, a great story I found in writing my book, is Powell, before he joins the Supreme Court, he's on the board of directors of Philip Morris for a long time, a lot of tobacco relations in his family. And at Philip Morris, they throw a party for him, a going-away party after he's appointed to the Supreme Court. And the head of Philip Morris gets up and they do this elaborate toast, multimedia toast, like goes on 10 or 15 minutes, and reenacting times in Lewis Powell's life with a humorous edge. And at the very end, the head of Philip Morris says, well, it's traditional for the friends of a new Supreme Court justice to provide that justice with his robes of office. And so he comes up, Powell, to the stage and is literally given his robes of office by Philip Morris. And it's sort of a sign of sort of how corporations are really going to be able to use the Supreme Court to fight back against the Ralph Naders in the years to come.
Well, there's so much more we can talk about, but we need to, of course, get to one of the big subjects that comes up here. And we've already touched on it, Kent, and that, of course, is Citizens United. I've read through the terrific questions from our audience. My rough calculation, and math is not my best subject, is 75% of the questions are about Citizens United. So maybe we should talk about it.
I think we should.
Tell us what happens in that case, and I'm curious to know whether you think it was correctly decided.
Okay. So this was a case about a movie. There was a nonprofit group called Citizens United, produced a movie about Hillary. This was in 2008 when she was running the first time during the primaries. And they wanted to make it available on-demand television, so you could order it. But there was a federal statute that said companies using corporate money cannot spend money for advertisements against or for a candidate within a certain amount of time before a primary and before a general election. And so the film, if it was considered a commercial, would have been against this, would have prohibited, would have been banned by this statute. So the question was whether the statute, which limited corporations' ability to spend money, was constitutional. So it gets to the court. It's actually argued twice. The first time it's argued, the lawyer for the federal government, the Deputy Solicitor General, makes a big mistake. One of the justices says, well, just hypothetically, would you think that the First Amendment would allow the federal government to ban books if they were in favor or against a candidate? And the lawyer said, yeah, we would never do that, but yes. And you could see the steam flowing out of the justice's ears, and the court reset argument for it to be argued a second time, and explicitly asked the advocates to rebrief the question about whether a prior case that had limited corporate spending rights should be overturned. That case was called Austin v. Michigan Chamber of Commerce, and the question explicitly on the table then was whether that case should be overturned. And it was re-argued in the summer. They don't like working during the summer, so this was a special situation. Like they asked for a re-argument. And this time, the Solicitor General of the United States, Elena Kagan, at the time, argued the case for the government. She didn't farm it out to a junior lawyer. So the question was squarely presented. Do corporations have First Amendment rights to spend money? Now, individuals, the court had held back in a case called Buckley 20 or 30 years before, that individuals do have a First Amendment right to spend as much money as they want, right? You can throw money and to buy advertisements, to buy materials. There is a cap on contributions. It's a little arcane, but it's sort of, and I have trouble teaching my students this sometimes. It is constitutional, the court held, to cap contributions, but not constitutional to cap expenditures. And so the question was merely, should the same rule that applies to individuals be applied to corporations? And the court said, yes, we're going to apply the same rule to corporations as individuals. Now, I do think the Citizens United was, I think, had a lot of flaws in it. It didn't, Justice Kennedy, who wrote the opinion, writes a big decision. It's a self-consciously a big decision. He could have narrowed the decision to be about nonprofits. He could have made it on statutory grounds, saying, well, this isn't an advertisement, this is a film. So there are a bunch of ways he could have avoided the topic, but he doesn't. He goes right to it and says corporations have a First Amendment right to engage in political speech and to engage in political spending just like individuals do. So, was it rightly decided? Yes and no. Here's what I think. I think the problem in America that politicians have to spend so much money raising money, that our democracy depends on money, I think that is a horrible flaw in the way we run our democracy. A lot of other advanced democracies don't do it that way. So I think there ought to be a constitutional limit on expenditures and on contributions. And so I think the original sin there is Buckley, not Citizens United. And in fact, I think money spent in politics is bad, whether it's spent by GE or Sheldon Adelson or George Soros. Too much money, and by some voices, drown out others. So I think the real problem is Buckley, not Citizens United. And as it turns out, after Citizens United, corporate money has not exploded, as it turns out. Super PAC money has, but you know who has been contributing to super PACs? Wealthy individuals, unions, and not so much corporations. You know, in 2016, the largest contribution to a super PAC from a for-profit, publicly traded company was $1 million contributed to the super PAC that was supporting Jeb Bush. So if you add up the top 50 contributions to super PACs by for-profit companies, it runs about less than $50 million. Tom Steyer gave over $50 million, $90 million. Sheldon Adelson gave $80 million individually. So it looks like for-profit, publicly traded companies are less than 1% of all the expenditures after Citizens United. So Citizens United has a lot of problems to it, but it has not created the explosion in corporate money that many of us expected. I think there's a lot more to be said about when corporations, what limitations you could put on corporate spending, and I think there are reasons why corporation spending might be different from individual spending. For example, I think it's completely consistent with the First Amendment for a state to say, in order for a company to spend money in the space, you got to get a shareholder vote. And I would even say you have to have a vote of employees, because those are governance questions, and those turn on state law. So in a way, one takeaway, that if I had asked you to take away what that Greenfield guy was going to say, the remedy for Citizens United and the remedy for the problems of corporate power in this country today are corporate governance remedies, not constitutional ones. So let me pause there. I think it's a bigger bigger
No, I
topic. but there's
appreciate, I
plenty to
appreciate
say.
that. Adam, I have a feeling you've got a thing or two to say about Citizens United. But, if I can, I want you to express
No, go
those,
ahead.
but we have a lot of questions here from the audience.
Yeah.
Let me, it's hard to know which one to come with next, but
Just ask any question, I'll give the answer.
but
I
one of
want
them is,
anyway.
okay, and one of them is Citizens United gave labor unions the same rights as corporations. Are labor unions people too?
Yeah, you know, labor unions are people too in fundamental ways, in the sense that they are independent entities in the eyes of the law that should have, in some ways, rights that they need to be able to protect. But they're not people in quite the same way. And one of the things to note, though, is that it is true that unions have taken advantage of Citizens United more, I think more so than many corporations have, although I think that may be just a time thing. One thing, if you look at the history of, I spent a lot of time, sort of a special focus in the We the Corporations, thinking about efforts to regulate corporate money in politics, because that is one of those central issues that we're so interested in. And part of the reason why I think Citizens United is wrong is because it overturns a 100-year-long commitment and compromise we had made, which was that corporations, we have a system that uses a lot of money in our elections, but that we would keep corporations out of electoral politics. That was a compromise we reached in 1907 with the first federal campaign finance law, which was the Tillman Act that banned corporate money in elections. And that was enacted very specifically to try to restrict the ability of corporations to influence big presidential elections. And what we've seen over the course of history since is that unions were eventually added to that ban too, prohibited from spending money on elections. And unions were the first ones to really push back against it. And we think about political action committees and PACs. Those were actually formed by labor unions in the 1930s trying to expand their political power in light of the fact that they had been banned from contributing directly to candidates. And corporations don't rush in and form PACs. It takes till the 1970s and Congress passing a law that clearly says PACs can be formed by corporations, that corporations then take to it. But when so they're really slow to take to this political reform, this reform to exercise, because they're kind of fearful of what's going to happen if they get involved in electoral politics. But once they do, within 10 years, by 1980, corporations outspend labor unions $3 to 1 in corporate PACs. So they're slow to adopt to some of these reforms, but once they adopt, they really take it over. And I wouldn't be surprised to see in the next 10, 20 years, if Citizens United is not reformed, corporations spending a lot more money. And maybe not so much in the federal elections that Kent was talking about, but in local elections, state elections, city council elections, zoning boards, things where corporations can make a huge difference with just a little bit amount of money. In presidential elections, overwhelming, there's so much money already. What difference can you make with your 50 million? Take that 50 million, put it on state Supreme Court justice races, and you can change the law pretty good.
And let me add one point.
Sure.
One of the reasons that we need to be worried, especially about corporate money, is not just because it perverts our politics, but because it perverts our economics. Right? Why do corporations care? They don't really care. They care not only about the outcome of specific elections, but access to those legislators and politicians after they become people in the legislature. And so if a company can use political spending to skew the marketplace to their benefit, it undermines the very reason why we have corporations to begin with. So one can say that there's a big danger to politics and to democracy of political money, but there's also a danger to economics and to our markets of political money.
So Ken, I want to ask you one other question, then we're going to come back to sort of any final thoughts each of you have. Lots of questions here about corporate law. I wish I could get to all of them. Let me get to at least one of them that may relate back to Citizens United. This question is about if Citizens United is not overturned, is there a way to alter the FEC report to allow for more transparency, Kent, and allow the public to know more about where the money might have originated?
Absolutely. There's no First Amendment restriction on disclosure, and I think there's a growing effort on the part of shareholders to force companies to disclose what the companies are doing. And I think there's a lot of ways that we can address this problem, even outside of the constitutional law space. And a bunch of my book that I hope you buy in a few months
Available for pre-order now, though, on
available for
Amazon.
pre-order.
So don't
Is
hesitate.
to say, so about the last third of my book is remedies. And I think the key remedy are corporate governance remedies. And like before you fall asleep, let me say what I mean by that. The problem is not that corporations speak; it's for whom they speak. And the obligations of for whom they speak are derivative of corporate governance rules. It's the Dodge v. Ford rule that corporations are to be managed for the shareholders and the managerial elite. In a bunch of other democracies and a bunch of other constitutional democracies, Western industrialized countries, the obligations of corporations run not just to shareholders, but also run to employees, also run to other stakeholders. And so my takeaway is that if corporations are going to play in democracy, then let's inject democracy into corporations to make them more democratic. And then if they're speaking for all of their stakeholders, I think actually our democracy might be better for it that they speak.
Adam, I wish we could get to the full history that you've written about, but let me point out to the audience, your book is going to be on sale in the lobby, where you're going to be, of course, happy to sign and talk to people about the book.
And I'm happy to sign the flyers.
And we're going to have to bring Kent back so he could physically sign them too. But Adam, in terms of, unfortunately having to wrap up our program here, curious to know where you think the law may be going at this point. In other words, we've got Citizens United. Where else can corporations go? In other words, if there's going to be an addendum to your book, what might it be?
Right. There are some rights that corporations do not have, but they seem to be seeking those rights now more and more. I mean, this is not, my book is a look back, how we got here, but the way forward, the questions really that Kent's addressing in his book, how should we answer the questions that arise coming up next? There's so many. I mean, we talked already today about the Masterpiece Cake Shop case. This is a big case about civil rights and the rights of business. We've had corporations that are being very creative in the constitutional rights they're raising. There are cases arising under the excessive fines clause of the Constitution where corporations are saying we're protected by that. There are cases where corporations are challenging living wage ordinances as a violation of their 14th Amendment rights. Indeed, there was one study of First Amendment cases, an empirical study that went out and found that 50% of all First Amendment cases brought today are brought by corporations and trade associations that represent corporations. So corporations are very active in using the Constitution to try to expand their rights, and there's a whole bunch of cutting-edge issues before the Supreme Court that are going to come up, and either are already before the justices or will come up in the near future. And unfortunately, I think the way we're going with the Supreme Court is to expand the rights of corporations ever more. We've seen that in Hobby Lobby. We've seen that in Citizens United. I hate to hazard a prediction of an outcome that I don't want, but I think we might get that in the Masterpiece Cake Shop too. Expansive rights for corporations, even while, on the other hand, the Supreme Court's limiting the responsibility of corporations. There was just a case decided this past week that said corporations could not be sued in federal court for human rights violations abroad. Again, limiting the responsibility of corporations even while we're expanding their rights. I think that for the foreseeable future, we're going to see more corporations making more claims of constitutional rights and using the Constitution even more to assert their power.
Thank you, Adam. And Kent, as Adam says, his book may be, although I think it's modestly said, his book is a look back, but it's a very rich history that, of course, that Adam
it's a wonderful book.
Brilliantly documents. And you've got a brilliant, really sort of critique of the legal doctrine. And one of the things I want to sort of have you talk about at the end is how you suggest that you think corporations should be treated more like persons in terms of the law, and maybe particularly in terms of constitutional law. Could you explain that a little bit at the end here? So
I think the key notion here is that there's some rights that ought to apply to the corporation, some rights that should not. It turns on not only, but we have to talk about what a corporation is for, and we have to talk about what the rights are for. The result does not fit on a poster. So you have to buy a book. That will spell it out. But here's the right. But I think here's the takeaway, that I think that once we are in a nightmare scenario. In corporate governance, they have a legal obligation to focus on the rights and interests of a small sliver of elite, and then those interests are turbocharged in the constitutional space. Now, I think the remedy could come from either side, but one remedy that is often ignored is to change the nature of corporate obligations. And how I think about that is that corporations should be more like people. If they're going to be people, let's ask them to act more like people and act more like citizens. What does that mean? I don't act as if only one thing matters in my life. If I did, I would be even more of a weirdo than I am, right? And I act as if my actions affect a number of people. I have to think about a whole host of people. Corporations in this country are asked to think about only one thing. And if we ask corporations to be more like people, the fact that they are constitutional people would be much less problematic.
Thank you. Well, you've suggested there's a nightmare scenario, but I want to remind everybody we're here in what Jeff Rosen calls constitutional heaven. And we have begun an incredibly thoughtful, important dialogue about corporate power, corporate protections under the Constitution. Interesting idea, concept that maybe we don't think about oftentimes when we walk into this building. I think it will enrich our understanding of the Constitution if we do. I really want to thank both our incredibly brilliant, wonderful guests today. It's been an honor to have you here. Thank you. Thank you, Ken.
That's great.
Yeah,
Thank you.
Here, wait, let's get a picture of us.
We will, okay. Oh, appreciate that. And then we'll get our mics off.